Imagine that one person goes to another's home to conduct business, such as providing home repairs. Does the visitor have any expectation of privacy under the Fourth Amendment while inside the other person's home? Or does the visitor have to be a social guest to be protected by the Fourth Amendment? The Supreme Court addressed this question in Minnesota versus Carter. Wayne Carter and Melvin Johns were drug dealers from Chicago who traveled to Minnesota to ply their trade. There, the two men made arrangements with Kimberly Thompson, with whom they had no prior relationship, to use her apartment to prepare cocaine for sale. Carter and Johns agreed to give Thompson some cocaine in exchange for using her apartment. The men spent 2.5 hours in her apartment packaging cocaine for sale. A passerby looked into the apartment's window and saw the men packaging cocaine. That person tipped off police officers. An officer arrived and approached the window of Thompson's apartment. Through a gap in the blinds, he was able to see Carter and Johns packaging what appeared to be cocaine. The officer arranged for a search warrant based on what he had seen. Carter and Johns left Thompson's apartment and drove away. Police officers stopped them, searched their car, and found cocaine. Pursuant to the warrant, the police also searched Thompson's apartment, where additional drug evidence was found. Carter and Johns were arrested and charged with drug offenses in state court. The two men filed motions to suppress the evidence found in their car and in Thompson's apartment, contending that the officer who peered into Thompson's window violated the Fourth Amendment. The state trial court denied their motions. After Carter and Johns were convicted, they appealed to the Minnesota Court of Appeals, which affirmed their convictions. Upon further appeal, the Minnesota Supreme Court concluded that the Fourth Amendment had been violated and reversed their convictions.